Welcome, everybody. Great to see so many participating in this webinar this morning, afternoon, depending on where you are, which time zone. We are here to discuss and also basically introduce the new Swedish National Human Rights Institution. Just yesterday, the Swedish Parliament decided to establish the Swedish National Human Rights Institution. It was passed in Parliament. So now there is a full green light, as we had also hoped, and I would also say expected after a lengthy process. On top of that, we of course very pleased that the minister made the decision a while ago that if the institution would materialize, it would then be in Lund. So therefore, the Wallenberg Institute of Human Rights and Humanitarian Law, of course, have a particular interest in getting a very good neighbor, colleagues here in southern Sweden, in Lund. But of course, there are a lot of questions, a lot of issues, and a lot of looking into the crystal ball to see what will this institution do, what sort of issues can it bring up, and what is the mandate, etc., etc. So that's what we're here to discuss today, and we have a very strong panel joining us. So I'm Morten Keum, and I'm director of the Wallenberg Institute, and before that I have also had the great honor and pleasure to chair the group of national human rights institutions globally as well as in Europe, since I was the director of the Danish Institute for Human Rights, which is a national human rights institution. Then we have our former colleague, Jason Naum, who is today an independent expert on national human rights institutions. Since I think Jason has worked on this issue since the mid-1990s, and really he knows this area in and out. So look forward to listen to you, Jason. And then we have Mia Algrain, Disability Policy Officer at the Swedish Disability Rights Federation. Good to see you, Mia, as well. As we will hear, the civil society is a key actor surrounding or supporting a national human rights institution. That is sort of I would almost say the basis of a national institution. And on top of that, the Swedish institution also will have a particular mandate in relation to disability. Looking forward to hear much more about that, Mia. Welcome to you as well. And then we have Anna-Karin Lindblom, inquiry chair for the establishment of a national human rights institution in Sweden. Anna-Karin, when she doesn't hold that prominent position, she is in the Ministry of Labour and has worked on this issue for a very long time, and is also extremely knowledgeable, and of course followed it closely from the inside, from the part of the ministry. So also look very much forward to listen to you, Anna-Karin, and welcome as well. So you see an exciting panel covering all the different elements that we are here to discuss. So I will just briefly open by saying a few words about where do these institutions come from? What is sort of the history? What is just something coming up? As I was asked a while ago, someone said, well, now Sweden has really come up with something novel that we may be able to export and sort of show to other places. It's not quite like that. The discussions about a national human rights institution started actually immediately after the adoption of the Universal Declaration of Human Rights in 1948. A group of countries such as the Soviet Union, Egypt, and other countries, they were pushing quite a bit for national human rights institutions. And you may be a little bit surprised, why would they push for such institutions? They did it in order to they tried to avoid that there would be an international human rights machinery. They didn't want the external scrutiny of their human rights performance. So they pushed very much saying, no, this has to be dealt with internally in our countries, and we create national institutions to do that. Then in the 1960s, we saw the big international conventions emerging, also at the European level. So the European Convention on Human Rights, with all the different mechanisms, the European Court of Human Rights and the treaty body systems in the UN, etc. And thereby sort of the interest from that group of countries sort of waned and disappeared. So there was a bit of quiet, not much discussion about national human rights institutions for quite some years. It popped up every now and then. Then things started happening towards the end of the 1980s, with the end of the Cold War, and in particular the whole democratization process that swept the globe. Starting out in Latin America in the 1980s, moving to countries on behind the Iron Curtain, seen from the Western side, seen from the Swedish side, the former communist countries, and the tearing down of the wall. So this democratization process was key to the development of national human rights institutions, because a lot of countries sort of asked themselves, hey, I mean, now we're becoming full-fledged democracies, but democracy is more than only voting, only regulating. How do we make decisions? There must be some value to it. There must be some norms, standards setting. What is it that we can do and not do in particular? And of course, here the human rights conventions, the human rights framework came up. But then also the discussion, but how do we take these human rights norms and standards from the conventions into the everyday realities in our countries? And then the old idea of the national human rights institutions re-emerged at the World Conference on Human Rights in 1993, held in Vienna, which had a very powerful plan of action, which was sort of the first step in relation to exactly that agenda of taking human rights from the law books into realities in countries. Also underscored the mechanism of national human rights institution and said states should establish a national human rights institution, and all states. This was not only for the new democracies, but back then there were around 4 or 5 such institutions. We had the Australian National Human Rights Commission, we had the French Commission, and also the institute that I was so fortunate to head, the Danish Institute for Human Rights, were also among the first national institutions. So a very little handful. And today, I think we have around 120 such institutions. So an enormous development. And there's no doubt when we look across countries, both developed and developing countries, former, old democracies, new democracies, these institutions have played a key role in creating a deeper understanding of human rights in the society, also pointing to weaknesses in our societies where we are not fully compliant with the international human rights standards. So this is very much sort of the development of it. Further, this was the Vienna conference in 1993. And then another thing happened later that year, 1993, was that the UN General Assembly adopted the so-called Paris principles, the principles that are governing, setting the frame for what it takes to be a national human rights institution. And this is exactly where I will hand it over to Jason. So Jason, will you take us through the Paris principles and sort of what they mean? Thank you.
Sure. Thank you very much, Morten. And I first wanted to say thanks very much to the Raoul Wallenberg Institute and to you, Morten, for holding this webinar. I think it's such an opportune time. It's a pleasure to participate. So what I will speak most about is actually factors ensuring independence and how they relate to the Paris principles. So without question, the most critical factor in determining the effectiveness of an NHRI is its capacity to act independently in pursuing its mandate. If you ask 100 NHRI practitioners and 100 heads of NHRIs, they'll all say the same thing, that independence is critically important. And So what I'm going to do is talk a little bit about these various types of independence envisioned in the Paris Principles. They range from legal to operational to financial. If we have some time at the end, I can also get into some other factors that are critically important as outlined in the Paris Principles. But if we jump right in with legal independence. So what is legal independence? Legal independence is all about the basis of how an NHRI is established and the guarantees of independence afforded to them. So the Paris Principles require that an NHRI be established by law. Now, this is typically an act of parliament. Increasingly, more and more NHRIs are being entrenched in the Constitution, which is the most preferred method. It's obviously harder to change a constitution, so it provides more stability. But what can't happen and what is not permissible is for an NHRI to be established by an executive act, so a presidential decree or an order. An additional factor that can contribute towards independence is having the founding or enabling legislation clearly stipulate that the NHRI is independent. Now, this may sound a bit trivial or simplistic, but having your legislation emphatically state that you're independent can really help. And if I were just to provide a little example from our neighbor, Norway, where the establishing legislation states that an NI carries out its the establishing legislation states that the NI should carry out its tasks independently and decides for itself how the work is arranged and organized. So simple but effective. That brings us a bit to operational independence. This is really about an NHRI's ability to set its own priorities, programs, projects, etc. And that the Paris Principles are also quite clear here and states that NHRIs should freely consider any question falling within their competence. And there are a few things that further operational independence. First, enabling legislation. Enabling legislation should empower the NI to adopt its own internal rules and regulations. Now, these internal rules and regulations should be consistent with public service norms, but like the Norwegian example I gave, they should be responsible for setting their own rules and regulations. This shouldn't be something that's handed down to it by government or parliament. In addition, NHRIs should really report to parliament. In jurisdictions like Sweden, the NHRIs report through the executive, which is typically done through a minister. The enabling legislation should require that minister to table those reports in parliament, and ideally have parliament discuss those and debate those reports, and ideally have then the executive respond to them and a timeline included for them to respond. A final point that I want to make that a lot of NHRIs have in their toolbox is the power to impose sanctions for failure to comply with lawful requests. Now, many NHRIs have this power, but actually never have to use it. Simply having it is enough to compel compliance. If an NHRI doesn't have that power, they should be able to refer cases to an appropriate authority. And that's something that can often be addressed in enabling legislation as well. Moving on to another critically important area is membership appointment. The way members are appointed is also crucial, and one should avoid at all costs, I would say, of having NHRI officials appointed exclusively by the executive branch of government. The best good practices dictate that this is a very transparent and a very participatory process that involves civil society coming together, academia coming together with a list of names to then transfer up through to the parliament and then eventually to the executive for appointment. A good example of this is Thailand, that does in that such regard. I could also mention Denmark, and maybe Morten can correct me if I'm wrong on how it happens in practice, but on paper, they have a very unique system, I think, where there's 13 members, 6 are appointed by the Council of Human Rights, 5 others are actually from the heads of leading universities, and the last one is appointed by the staff of the NHRI. I've never seen that before, and I think that's quite a unique twist, and I think one that also could be adopted by other NHRIs. Bottom line is, though, that the appointment process should be prescribed, it should be transparent, and it should be participatory. A few other factors I'd like to mention in terms of membership that can lead to greater independence include fixed terms. Terms should not be too short. A very short mandate can impede organizational stability. You should have the possibility of reappointing members, which facilitates a continuity of leadership. There should be immunity from prosecution for actions taken in official capacity. We see increasingly that leaders and heads of NHRIs are the target of states, and really having an immunity clause in there establishing our enabling legislation can help quite a lot in allowing members to fulfill their mandate. And the final point I wanted to make is in relation to dismissal. There should be no dismissal without cause. Again, if I give an example from Norway, which is sort of the middle ground, I would say, the Norwegian's legislation states that the President of Parliament can only dismiss a director as a result of committing a serious breach of duty or other significant breach of employment contract. Now, while I would have liked to have those grounds outlined in the Act, referring to it as a serious breach is a step in the right direction. And I think here, when I compare it to the Swedish legislation, I think there's still some room for improvement. The Swedish legislation states something to the effect that the government may dismiss a member if there are special reasons. Well, what are those reasons? Those reasons really need to be qualified in the legislation, or at least enabling legislation. So moving on to the last category I wanted to discuss, which was financial independence. So not surprisingly, NHRIs are not entirely financially independent. They are state institutions, after all. They rely on states and governments, and parliaments to provide their core operational budgets. And the Paris Principles is also quite clear here, and it states that NHRI should have adequate funding to enable it to have its own staff and premises in order to be independent of government and not subject to the financial control which might affect its independence. And that's quite a mouthful there, but let's unpack that a little bit. Essentially what it's saying is the budget needs to be adequate to their needs. One can envision an NHRI with a large territory that requires potentially provincial offices, and may require staff traveling from one end of the country to another, and there need to be adequate resources to enable that. So a final way that helps NHRIs with furthering their financial independence is having actually Parliament approve an annual budget, and not the executive government. In jurisdictions where NHRIs are required to report to Parliament, they're also often required to submit work plans, strategic plans that are debated. This allows the debate and the correlating debate in relation to the budget to come to light. It can be discussed, and it can help mitigate the situation, which often happens where you have an NHRI that one particular year releases a report that's critical of the government, and the next year they have their funding cut in half. So having the Parliament involved can really help mitigate some of those circumstances. As I'm looking at the time, it seems I'm coming to my end here. So I think I just wanted to briefly touch on those 4 areas of independence envisioned in the Paris Principles. And I think one of the key things is obviously Parliament. And I think for those of you that are interested in learning more about the relationship between Parliament and NHRIs, the Belgrade Principles adopted in 2012 were a great way to speak quite a lot about independence, but also about the relationship Parliament should have with an NHRI.
Thank you very much, Jason, and you're actually doing excellent on time. To the extent that I would actually ask you a question, and that is if you could just in 2 minutes say a few words about the substantial part of the Paris Principle. What is it that the institution should do? Sure.
So obviously, an NHRI needs to have a broad-based mandate. It's based on universal human rights, and obviously, what makes an NHRI special is it's established by government, it's supported by government, but it's independent of government. And they have the mandate to both promote and protect human rights. Without that mandate to both promote and protect, it wouldn't be an NHRI. And there are several core specialized functions that an NHRI has. These range from providing advice, monitoring, education, and there are a number of different things an NHRI can do that really push forward the human rights agenda. One thing that we talk about when we talk about essential characteristics that an NHRI should have that are in relation to independence, but not specifically, are also a pluralistic membership. An NHRI should have a membership that matches society. So it should have members that are from all segments of society, all racial groups, disability community included, and it should also be accessible, not only in physical, social, cultural, linguistic, but also financial ways. So we're talking about a situation where an NHRI You can imagine a country like South Africa that has 11 official languages. It means you have to produce materials in languages that everybody can digest.
Very, very good, Jason. Great. And I think this just sort of gives a very nice bridge to Mia Algrain, who is, as I said, from the Disability Policy Officer at the Swedish Disability Rights Federation. So very anxious to hear from you. Mia, over to you.
Thank you very much. I'm so happy to have been invited to speak on behalf of the Swedish Disability Rights Federation. So we're representing 49 organizations of persons with disabilities. And we've been working together with many civil society organizations working on human rights in Sweden. And we have been active in a network to support the realization of a Swedish national human rights institution for many, many years. And you can imagine last night we were very happy with the decision in the parliament. Of course, I would like to start speaking a little bit about this UN Convention on the Rights of Persons with Disabilities, the CRPD, not only because that's the convention I know the best, but I also think that it's a modern convention that should be used much more to inspire the overall human rights work, and especially when it comes to independent monitoring. The text, first of all, in this convention was co-designed with both duty bearers and rights holders. So all 182 state parties to this convention, and it includes the European Union, they have taken on the obligation to establish an independent monitoring mechanism in line with the Paris principles to not only promote, but also to protect and monitor the implementation of the convention, and also closely consult with the civil society organizations, especially organizations of persons with disabilities, in the monitoring. So this goes much further, and it's more explicit than other conventions. And I really think we should read it more, because not many have read it, I think. In Sweden, you might get the impression from some stakeholders that ratifying a convention is a signed, sealed, delivered almost activity. Once you've done it, you're ready. But of course, we that are here today, we know that's not the case. So it's hard work. We have to monitor, reviewing legislation, addressing gaps all the time, and keeping up to date with the work of the UN committee's development of general comments, jurisprudence, etc. And we can see more of this continuous work happening in the European Union than we see in Sweden. So since 2009, when the CRPD entered into force in Sweden, we have been without this independent monitoring mechanism that is an obligation. And we relied only on duty bearers' self-assessment of the implementation. And this has taken its toll. So when CS, civil society organization, reviewed the implementation of the CRPD 10 years after it came into force, we sat down and we looked at the text in the convention, just as state parties should do. We reviewed the text and we looked at what had happened. We found research, statistics, etc. And we came up with so many barriers and gaps that we found 134 recommendations to the state that we have to address. And as I said, it's something that I think is not only the work of the civil society, it should be the work of the state parties as well. And what we found in particular is that the human rights approach to disability has not gained momentum in Sweden, even so many years after ratifying the convention. There are still gaps in the constitution, and we can see barriers when it comes to access to justice, and I could go on forever. I would just like to mention also that we even see a regression when it comes to instead of progressive implementation of social and economic rights. We've seen that for the last or for the years between 2008 and 2018, the risk for poverty for persons with disabilities grew at the fastest rate in the whole of European Union. And this I would like to address. It's data from Eurostat so that the state party should be aware of it through the public agencies responsible for assessment of the implementation of rights. But this negative trend has not been widely known or addressed. So it's extremely important to stress once again, as many others have done, the independence of the Institute in relation to all public agencies, even those who are involved today in promoting rights. So there is some text in the bill about working closely together with, for example, the Public Agency for Participation, but we need to have an institute that can address issues even for those agencies. We expect the Institute to have a special unit to fulfill the obligations in relation to the CRPD, but we want also to stress the importance of adopting a twin-track approach. So a twin-track approach is described in the UN guidelines for monitoring of this convention. It's a combined approach of specific policies for supporting and empowering persons with disabilities, along with the mainstreaming of disability rights across general policies and programs. So the mainstreaming of rights, it's not working, not at all. If we talk about persons with disabilities, anything that has to do with persons with disabilities in Sweden is given to a small unit within the Ministry of Social Affairs. The same is happening in the Parliament. They are taken into the Committee of Social Affairs, even though human rights are treated in other committees. So what I would like to stress that we need to learn more about intersections and what is known as inclusive equality. That's another innovative part of the CRPD. It stresses that disability, age, gender, sexual orientation, ethnic background, etc., they're just different layers of a person's identity. You can just not look at one part of the identity and make sure that rights are respected for everybody, but it might need different actions. So let's conclude. Civil society, we are prepared. We follow the international treaties and we cooperate internationally and nationally. We keep alert and up to date as best as we can. And we do not expect that the Institute will solve all national human rights issues on their own, but we all urgently need an independent, strong voice with deep knowledge, integrity, and authority, working like a blowtorch to engage all stakeholders to fulfill and respect human rights.
Thank you very much, Mia, for this excellent presentation. And I really have to say that without the push from the disability, civil society, and also you personally, as well as, of course, other civil society organizations, I don't think this institute would have ever come into fruition. And that's in a way very positive, because it is this sort of ownership that Jason also talked about in relation to national human rights institutions. It needs to be anchored in civil society with people, not as an NGO and not as part of civil society, but getting the knowledge, the inspiration, and getting in order to detect what are the issues in the fringes of the Swedish society. You mentioned of course, the disability area. There's so much that needs to be done, and also things that are under the radar of media, politicians, ministries, simply because it's not really known. And this is where the national institution is a fascinating tool if it's played rightly. To actually reach out to the fringes of our society in a close engagement with civil society, religious communities, and you name it. So having that interaction is key to the success of a national institution. So thanks a lot, Mia, and let me now pass the floor to Anna-Karin Lindblom, as I said, inquiry chair for the establishment of a national human rights institution in Sweden, and has been involved from very early days on this. So great to have you here, Anna-Karin.
Thank you very much, and thank you so much for taking this initiative to invite us all to this seminar after the important decision of the Parliament yesterday. It has been such a long journey. Many of us have been involved in many ways, and I would especially like to thank civil society and the network for pressing for the issue for so many years. Of course, the legislation, the institute that will put in place may not be perfect in all aspects at once. It will have a long road to go, but after all, it's a very important decision that it is to be established now. And my assignment is to establish it in a rather practical sense, find facilities, some staff, etc. And the arguments why to establish the institute have in that sense already been put forward before. But if I dare to make my personal interpretation of these arguments of the added value of the institute, I think that the added value could be summarized in 5 C's. And the first C is a comprehensiveness, or a comprehensive view to Sweden's human rights obligations, both the international obligations and the national obligations. No single actor has this role today, or this broad or holistic perspective, and I think that this will be a very important function of the Institute. There are other actors in place, other agencies, etc., ombudsmen, that have roles that will be partly overlapping in a sense, or have to do with human rights, but still to see the full picture of all the obligations together and how they interrelate to each other is a very important task. And I think that is specifically important when it comes to perspectives that are usually regarded to be something that should be mainstreamed, like, for example, the rights of persons with disabilities. You really need to see all the obligations together in order to do mainstreaming work. My second C is continuity. The fact that the mandate of the Human Rights Institute is based on a law, even though not on the Constitution, it is still a law adopted by Parliament, will hopefully provide a stable mandate for it. It has been a long road, as I said, but still the Parliament has now taken the decision, and I think it would take a lot to take a step backwards again. So I think and I hope that the mandate will be stable. And continuity is, of course, also important because human rights, like democracy, can never be conquered once and for all. You need to work on them all the time, and that's why continuity is so important. And temporary measures on different national agencies, for example, aren't enough. You need some actor, some machinery that keeps on working continuously. My third C is competence and knowledge. Assembling knowledge on human rights obligations, human rights instruments, and their implementation in Sweden from this broad perspective that I mentioned before will create a very good soil for creating new knowledge, for attracting competence, I think. And if you attract competence, human rights competence, which I'm sure that the Institute will do, this competence will attract more competence, I'm certain. So that will create this soil for knowledge to develop gradually and always be up to date. My fourth C is coordination. Human rights is a wide and complicated area, and many actors have to be involved for a right to be implemented and realized for an individual person or for a group, of course. And even though the Human Rights Institute will not have a formal role to coordinate other agencies, because it has this broad perspective, I still think that it could have this coordinating role of assembling information on what different actors do, where the gaps are, where we need to take steps forward, etc. And therefore it could facilitate coordination in the field of human rights. And also provide overview to the government and to the parliament, of course, the Riksdag. My fifth C, my final C, is credibility. Sweden as a country that aims at being a firm and clear defendant of human rights needs to have its own stable structure nationally, of course. Also, in accordance with the Paris Principles and also in accordance with all the recommendations that Sweden has received and also accepted in this field a number of times. So that were my 5 C's: comprehensiveness, continuity, competence, coordination, and credibility. Having said this, of course, it will not be an easy task for the Institute to find its role and a good balance in its work. It has very many different issues to deal with at the same time, and I think that there are rather high expectations on it too, and I hear that there are high expectations. It will all come down on finding the right role, finding the right approach in relation to other actors, having an open dialogue with them, and formulating the relevant priorities in relation to human rights issues and in relation to what is already done by others, etc. When it comes to the way forward, there are very important steps to be taken ahead, not so easy steps. The first step is that, as you know, the Institute is to be governed by a board, and the board members will be appointed by the government after the nominations from different actors. And this part of the legislation on the Institute will enter into force on the 1st of October, so the government can start appointing board members from the 1st of October and onwards. And it's crucial to find the right balance and the right people to be on the board, of course, of the Institute. So that will be an important step. And when the board is in place and has entered its formal assignment in January, the board is to appoint the director, which is, of course, also a very crucial task and very important decision for the board. And the board is to appoint the advisory council. That will be another important task. The advisory council needs to reflect civil society in a good way. It needs to include competence and representatives from different parts of civil society, and that includes competence on the rights of people with disabilities. But as you know, the Institute will open in January. It will only have a limited number of people in its staff, a limited number of people in place. So it will be rather busy with handling all these important steps, and at the same time functioning as a national agency in relation to all the laws and regulations that regulate all national agencies. It needs to function in relation to the public, etc. When all this is done, then, of course, accreditation is a crucial step. Sweden's human rights institution need to seek accreditation with the Global Alliance, and hopefully it will gain A status. But I guess that it won't seek accreditation at once, but after a little while. So once this application is tried by the Committee on Accreditation, that would really be a defining moment for the Institute to see whether it can gain A status. No pressure, but it must not fail, I would say. So I really hope for that to work. So finally, I would just like to stress that I think that the Institute will need to have a very open dialogue with the society around it, with actors such as the Raoul Wallenberg Institute, of course, with civil society, with the ombudsman in the field, etc., in order to have a complementary role and not overlap too much with what other functions are already doing, but to be open, have a constructive dialogue, and gradually find its way forward. So, thank you.
Thank you very much, Anna-Karin, for this presentation and taking us through the 5 C's. I think the 5 C's will stay with us as a sort of a guiding stars for how this will progress in years to come. So thanks a lot for that. While we have been speaking here, we got a very nice greeting to the new institution from our friends in the European network of national human rights institutions. They have a secretariat in Brussels, and they send us a greeting in the chat, and they welcome the new institution when it's ready, when it's up and running. So that's good to know that there are a lot of friends out there, and I can speak from my own experience that having that network of national human rights institutions, both at the European as well as the global level, is crucial. It's just so important to gain inspiration, insight, and having sort of a collegial discussions. So very nice greeting from Europe. We have got a lot of questions and comment. That's great to see. And we can definitely not reach all to reply to all of them now during the next 20 minutes. What we promise, I got a very nice message from my colleague who is following this and said that they will do their utmost to reply to all the questions on our website. So if your question is not an answer to it is not coming up here, don't frustrate. We will see to that the questions are replied to as much as we can. And we may also come back to some of the panelists and ask for their view on some of the questions. But let's move ahead immediately with the first question. And I think that is probably to you, Anna-Karin, because the question is, can a national human rights institution propose a new law for the consideration of the parliament based on their finding gaps in their studies? So basically, can they come to the parliament and ask for them to come up with new laws? So what does the Swedish law say?
Yes, it can, in the sense that the institute is there are no obstacles for it to do that. But as far as I understand, the proposition will be in the form of an information to Parliament, because there is no sort of a formal way for the Parliament to accept the suggestion. So it will need to be processed by, for example, the members of Parliament and the parties of the Parliament. So it can make such suggestions, yes, but it will not go directly to the Parliament itself, so to speak.
Maybe you could also reply to another question here now when you have the mic, and that is that if the new institution would be able to deal with as a quasi-judicial mechanism to handle human rights violations. I think there's a quite clear answer to that one, so you may as well take it.
It will not. The institute will not deal with individual human rights.
Your mic.
Oh, sorry, there was some technical problem. And the institute will not deal with individual human rights violations. No. Thank
you. Then there's one for you, Mia. If there will be a possibility for shadow reports from NGOs. I assume the person asking is sort of thinking about the sort of shadow reports that the civil society do for examinations in the UN for the treaty bodies. So when Sweden is up for examination in this or that committee, that civil society do shadow reports. Will that be taken over by the national institution, or how do you see that?
Of course not. No. The National Human Rights Institution, at least when it comes to the CRPD that I know the best, they are doing their own reporting, and they also cooperate on the convention. And civil society will continue making their own reports. So that's But that it's very most national human rights institutions, they make their own reports to the committees when there's a constructive dialogue.
Exactly. It was actually a discussion in the early days of national institutions if they should do the national report to the committees. I think it was the UN Child Committee that in one of their general recommendations made it very clear that no, that is not the task for national human rights institutions to do the state reporting. That would be a mistake. Then later on, and actually we were a small group of persons from national human rights institutions that were members of the UN Committee on the Elimination of Racial Discrimination in the early 2000s. And there we sort of teamed up and opened up for national human rights institutions to actually be questioned by the committees in their own rights. So not being part of the official delegation and not from the seats of the civil society, but basically being there in the room in their own right. And I think more and more committees have followed that practice. I think Crpd and some of the newer committees. So that started back then. So
there is an interesting example I would just like to mention. It's the European Union, because their independent monitoring mechanism is the Fundamental Rights Agency, together with the European Parliament, together with the European Ombudsman and the European Disability Forum. So the rights holders are in it. But so that's an interesting thing. But I think that it's interesting with the CRPD because it's so different from other conventions when it comes to independent monitoring. So there's also a development within the national human rights and the committee looking at how to progress separately.
Thank you, Mia. Then I think there's one for you, Jason, and that is in a concern. I mean, you have worked so much with national institutions in different places, and there could be a concern that the expressions or the statements from national institutions or from the Swedish national institution is being perceived as just, let's say, an opinion. This is another opinion, like so many opinions out there. In particular, if the issues are critical to, let's say, the government or to this or that political line. So how do you see that? Is that a real worry? Or?
Yeah, well, that's a good question. I think it relates a little bit back to what you started to say about having the NI have roots and good cooperation with civil society. I think if there's perceived legitimacy there, if people believe in the leaders of the NHRI, if they believe in the competence that they have, and back to Anna Karin's 4 C's there, I think that they'll not necessarily view it as an opinion, and more they'll see that it's authoritative view on what's going on. But that all starts with cooperation. That starts with, having good relationships with not only the government, but with civil society. And if those relationships are there, I mean, although, you mentioned, Anna Karin, that NHRIs don't necessarily have the job of coordinating human rights in a particular country, they do have sort of the job of interacting. I mean, it's clear within the Paris Principles that they need to interact with other bodies in society. Any body that has a vested interest in human rights in the country. And by doing this and building bridges with other agencies, whether it's other ombudsman institutions or the NGO community, they'll build up a reputation that will help when they do make an opinion that there's credibility attached to it and that people believe in it.
Thank you, and I can add to that being in the receiving end of that sort of critique when I was heading the Danish Institute for Human Rights, I can only say that the best shield you can do is to be extremely rigid in relation to using laws, using the legal framework that you find in the international conventions. I mean, and I can say we did it many years ago. We sort of make a scoreboard for the critiques that we had raised against new legislation, and of course we were hammered at from the political parties who wanted that particular piece of legislation because we critiqued it. And and then it was often passed anyway, despite the critique from the national institution, which of course is not so good. Then we went back and said, what did treaty bodies, what did the European Court of Justice or the European Court of Human Rights actually say to these particular issues? And I think we have something like a 95% score, where sort of say the critique that we raised was, and then the law was anyway passed, and the critique came back then from the international or the European system. And there I think it's important to sort of have a broad understanding of, yes, I mean, as a national human rights institution, you cannot be opportunistic and say, okay, this is very sensitive, so we better go along. I mean, because then you're really giving poor advice. So if later on the international machinery come and criticize Sweden for having done this and that, and they turn to the national institution and say, come on, why didn't you advise us back then? Yeah, but we didn't, and you know, it's sensitive. And we know what the sensitive issues are in our communities, and where and what it is that creates the headlines and all the nasty language on social media. But I mean, this is where the national institution is tested, tried and tested. And I can say it's not always easy, but that's where you need good friends and a good network, both internationally as well as in other segments in society. One question that was raised to you, Anna-Karin, is on business. If you foresee that it would sort of the institution would interact with the business sector.
I think that the institute should interact with most sectors in society. So I think so, yes. But of course, it needs to be very aware of safeguarding its integrity and make sure not to become involved in sort of business in the sense of making a profit from a campaign or something like that. So it should really have an open dialogue with business, with civil society, with other actors, but also always safeguarding its integrity. That is crucial.
Thank you. And a question for you, Mia. If there are there any good examples, international examples, of what a CRPD Article 33 mechanism managed to achieve? So what is it sort of what is it we can expect from this mechanism?
First of all, I would like to say that I think we need more research because to actually know what is the role of the independent mechanism. Because when we look at the research that's being done, we often see Anglo-Saxon countries like Australia, you know, and so forth, where they've had a tradition of anti-discrimination acts and the rights perspective. It's much more secured in those countries. So first of all, I think more research is needed, and I think we have to look at the whole picture, because Article 33 is the coordination within the duty bearers, the state party, it's the independent mechanism, and it's the civil society. It's three parts. And to really see what is the success of the independent mechanism, we have to look at the whole picture. So Australia is interesting also because I think that they have another part of the government who is taking care of human rights. So and there we have much more entities that are working with the rights. So. Definitely, when you have a good and a long tradition and that gets a role, you will get more actors to take on the human rights perspective. I think so. And the European Union is interesting, as I said before, because of the close cooperation between these different parties. For example, within the European Parliament, there is a very close cooperation, and they have different roles on the monitoring in different committees. So. Maybe that's something, but more research, and you will help us with that, won't you, Morten? Absolutely.
No, and this is where we look so much forward to develop that complementarity and synergy with the new institution. I mean, it really creates a strong outset that it's placed in Lund. And of course, it should also be mentioned in this regard that Lund is the first human rights city in Sweden, and I actually think the first in the Nordic countries. So it's perfectly sort of building on that it's now being based here. So we foresee a very rich agenda. You have now mentioned the EU level a few times, and I of course very much agree. And what is interesting to see is the EU Fundamental Rights Agency actually having in the national human rights institutions in its board. So you have sort of the independent national institutions being part of an EU independent organization. And actually the Irish invited the Fundamental Rights Agency, the EU Fundamental Rights Agency, to be part of the recruitment of the chief commissioner. So they really created that organic link between what happens at the national, what happens at the EU level. So there's a lot of, let's say, interesting architecture, human rights architecture developing these years that Sweden can now take even more part of with the new institution.
Ireland is just interesting. I would just like to say that because they have more research on disability rights, and that's an important factor as well.
Yeah, absolutely. Jason, there's a good question here, many good questions, all are good questions, but here on if you could specify some national human rights institutions in developed countries, so to say, like Sweden, and of course you have to mention Denmark now, but that you say have been particularly effective, and why were they effective?
Oh, very good question. And this is always one that's debated. I mean, the effectiveness of NHRIs is something that's continuously debated. It's hard to put a blanket sort of coverage over the effectiveness of an NHRI. I think NHRIs often go up and down with effectiveness, and it's often pinpointed on one particular issue. They may be focusing on one particular issue and do incredibly well in that issue, but then are having difficulty in other issues. The problem for me with addressing this specifically is my work is focused mostly in developing countries. I know that the Irish National Institution is very strong, has very strong legislation. The Danish Institute, as you mentioned, has had some good success. I think one of the problems that I have with a number of the European institutions is very few of them have a complaint handling role. So it's hard to look at how they interact on that front, and it's a lot more research based. So a lot of the work gets done and they can be effective, but it's long-term sort of effect. It's sort of long-term sort of change that takes a lot longer to look at in terms of its effectiveness. Whereas if we look at those institutions in developing countries that have a complaint handling role, that are more proactive in going after doing a national inquiry into a particular issue, you can see in that particular issue that they've made progress, that things have changed within the national legislation or what have you. It's hard to do that in some of the European institutions because they are more research oriented. So a lot of what takes place is going to be a longer term thing. So it's hard for me to pinpoint exact change without talking about NIs that have been set up with quite good legislation. It's difficult for me to point my finger at one that I would say is a shining, flag to point out as being incredibly effective in the European setting. There's a lot of reasons why NHRIs in Europe don't have complaint handling functions, but I think one reason we can talk about with NHRIs in Europe is they have a number of other bodies like ombudsman institutions that they cooperate with. And so it's not all placed on the shoulders of the NHRI. They do it in conjunction with a number of other agencies. It's critically important that they do have that bird's eye view, that macro view to look over everything and get a holistic approach to things. But often NHRIs are doing it in partnership or coordinating with other actors that maybe be doing more of some of the heavy lifting, at least at the European setting, I would say. Maybe more, as a former head, you would have some examples from the Danish Institute that could illuminate it a bit better than my experience.
Thank you, Jason. And I think that will also be the last question. Actually, what you're just referring to me is also a question in the. So just one or two words on that before I close, saying that I think the Danish Institute contributed first and foremost to actually put the human rights on the agenda, human rights in Denmark. As we all know, up till the early 90s, human rights in our part of the world was always about faraway places. And the further away they were, the easier they were to solve. And the closer it got to home, the more complicated, and you suddenly saw all the nuances, and thereby also got all the, let's say, the heated discussions. And I think we will probably witness that in Sweden as well. With the new institution, I'm actually quite certain we will, that the more you start using human rights language domestically, of course, there will not be consensus as there is when it's all about faraway places. So that is definitely an element, but of course also deepening the issues. And I would say I think the Danish Institute put a big fingerprint on in relation to disability rights, racism, Roma, and a lot of questions, also freedom of expression, and so forth. So there's a long list here. So I will now thank the panel warmly for this dialogue that I have felt was extremely inspiring, and also a lot of very good questions. As I said, we will try to reply to them. And then I say that some of my colleagues, while we were sitting here chatting, have notified me that they are so inspired that they have said, we will continue these webinars. So certainly this has turned into the first in a series and not a stand alone. So therefore, I would also call on all of you who are here now to come in with themes that you would like to address, that we should focus on. I mean, one theme, for example, is how will this institution relate to the other institutions that are already there, the discrimination ombud, the general ombuds institution. What sort of interaction do we is foreseen here? And there are a number of other questions that can be raised. So please let us know what you would like to discuss, and we will then try to make some interesting panels and interesting discussions. So with that, a warm thanks to everybody, and I look forward to seeing you all again and work on this very important task for Sweden. So thank you. Have a nice afternoon.